Agriculture. It's interesting because on page 64 of this plan, they talk about the history of agriculture as it pertains to cultural resources in the Santa Monica Mountains. They talk about it in the sense that they want to preserve the archaeological resource of the agricultural history and heritage that we have here. They talk about the fact, did you know that there was 1,500 homesteads in the Santa Monica Mountains? 1,500. And of course, you go back hundreds of years, and some of the earliest agriculture in California, some of the first vineyards in California were here in Santa Monica Mountains from the Mission San Fernando. In fact, Topanga Canyon is a good example. Topanga Canyon, anybody ever drive on it? It's obviously a rhetorical question. Did you know that Topanga Canyon was made with dynamite and mules and shovels? And do you know it was the ranchers that built Topanga Canyon? It wasn't the government. There was nothing but farms, orchards, vineyards, cattle, and sheep operations in the Santa Monica Mountains for a very, very long period of time. And this is reflected in the Santa Monica Mountains National Recreation Area Plan. This is the federal guiding document for the entire Santa Monica Mountains, where they're supposed to not only coexist with the property owners, but under federal law, they're supposed to respect our cultural heritage. And our cultural heritage is, in fact, agriculture. How ironic, therefore, that they're proposing this LCP that will completely do away with agriculture within the Santa Monica Mountains. Now, the Coastal Act prioritizes agricultural use. I'm going to read to you a couple sections of the Coastal Act. 30106, do you know what the definition of development is? You just engaged in development. You walked in here, you parked your car, you walked in. Okay? Development is the placement of any gas, liquid, or solid on, above, or below the ground, temporarily or permanent, including the removal of major vegetation, except for agricultural purposes. Now, there's going to be a common theme you're going to hear throughout this presentation. We have a real dichotomy between the law, which is the Coastal Act, that was passed by the people that we elected. It became law in 1976. The Coastal Commission itself was created in 1972 pursuant to a proposition. It had a sunset clause in it, and they had to pass a law. And so our lawmakers worked long and hard, and they created the Coastal Act to, yes, protect natural resources, yes, to promote access to and along the shoreline, but also to be a guiding document and to allow appropriate development. And it emphasizes over and over and over agriculture. It's supposed to be one of the priority uses in the Coastal Act. Section 30241 of the Coastal Act specifies that the maximum amount of prime agricultural land shall be maintained in agricultural production to assure the protection of the area's agricultural economy. Passing a law that outlaws agriculture does not do that. And by the way, is this in fact prime agricultural land? Take a look around you. The coastal staff like to say, no, it doesn't, it's not Class A soils. You do not grow fine wine. You do not grow an orchard, in most cases, in the same soils in the Ventura Plain that you grow soybeans and you grow strawberries. We have award-winning wines and excellent produce, and organic farming is just exploding here in the Santa Monica Mountains. They call it the homesteaders, back to the earth, urban farming movement. It's become very, very large over in Topanga Canyon, for instance. And Section 30242 goes on to say that even if it's not prime agricultural land, all other ag lands suitable for agricultural use shall not be converted to non-agricultural use unless continued or renewed agricultural use is not feasible. Look around you. Is it feasible? There's absolutely no doubt about it. In 1978, the executive director of the California Coastal Commission asked for a formal opinion from the Attorney General. What does this exemption of removal of vegetation for agricultural purposes really mean? And so the Attorney General went back and he went through what's called the legislative histories, where they look up the minutes from the deliberations of the lawmakers. What did they mean by passing this law and having this definition? And the Attorney General issued an opinion to the California Coastal Commission. It means exactly what it says, which is a property owner, if they want to clear vegetation, native vegetation, to put in a vineyard and to put in an orchard, or to plant an organic farm, that doesn't require a permit. Now, for a number of years, the Coastal Commission respected that, but then they just started to basically ignore it. And in fact, they've had litigation on it, and they will tell you that they have won, but they haven't. Let me explain. There have been farmers here that have received violations, and if you've ever received a violation from the Coastal Commission, it makes going through something with the IRS look like a pleasant experience. They can, in fact, fine you $15,000 a day for a knowing and intentional violation of the Coastal Act. There have been property owners that have received multi-million-dollar fines because they cleared brush on their property, and the Coastal Commission went back and looked at old aerial photographs and said, oh, well, that's sensitive resource, you cannot legally clear it, it required a permit. Now, where they have successfully won in court, they being the Coastal Commission against property owners on these violation issues, is the property owner would then come in and plant the vineyard and put in the stakes or put in the orchard and put in the irrigation for it. That is, in fact, development. That is something that does, in fact, require a permit. But the clearance of the vegetation does not, according to the law, according to the Coastal Act, according to the Attorney General's opinion in this case. Now, what this means is there's a whole lot of property owners, neighbors that you have here, maybe some of you, that have cleared chaparral on your property, and you have an enormous liability hanging over your head. How big? Well, what they'll do is they'll look at the aerial photographs, and let's say you bought your property in 2005 or 1995, and you cleared an acre on your land so that you could put your alpacas out there. I have some alpacas. And that was going to be your pasture area for your alpacas. They can, in fact, go back, look at the aerial photographs from 1992 or 1985, and if you don't play ball, they can fine you up to $15,000 a day for every day that that land was cleared. So this has enormous, enormous implications.